I've been extremely emotional since my dad's death.
Deputy Grady, I wanted to tell you that I'm sorry for what happened.
Because he took my husband and my son.
She decided to kill her. She was going to kill his mother.
I pray that she too carries the weight of my uncle.
Brittany Miles, a former exotic dancer, pleaded for mercy from a judge after being convicted of fleeing from a drunk driving stop in Pasco County, during which she seriously injured a deputy. She was sentenced to 15 years in prison. In court, Miles claimed she had changed since getting off prescription pills and hoped for a lighter sentence so she could return home to her family and young son and help others struggling with addiction. However, she received no sympathy from one of the people she had hurt.
Deputy Grady, I wanted to tell you that I'm sorry for what happened.
For the first time, Brittany Miles apologized directly to the Pasco County deputy she had nearly killed during her escape.
I did not mean to hurt you, and I am sorry.
The former exotic dancer and her family pleaded with the judge for mercy during the sentencing.
What happened that day was not my daughter.
Her mother, a Hernando County deputy, said that Brittany was a wonderful girl until she developed a pain pill addiction, which began after she was hit by a drunk driver in 2009.
I know that if she wasn't her right frame of mind that day, none of this ever would have happened.
However, Deputy Grady, who was suspended for mistakes that contributed to Miles's escape, isn't convinced by the excuses.
Even on the pills, people still make their own decisions. I feel that Brittany Miles is clean today and the person she used to be because she had no choice because she was sitting in jail.
Deputy Grady broke her leg and suffered a concussion when she was thrown from Miles's truck during the escape. She says she will have to live with her pain and injuries for the rest of her life, but has chosen not to take pain pills.
I told the doctors I refuse to take medication because I've seen what it does to other people.
Authorities reported that the rampage up US 19 came to an end when Brittany Miles crashed into and killed motorcyclist Henry McCain just across the county line.
I didn't realize that I had a real true problem till it was too late.
Miles could have faced a maximum sentence of 35 years, but she received 15 years instead. She still faces another trial in Hernando County for the death of motorcyclist Henry McCain, which could result in additional jail time. Martin Linscott never spoke directly to Paige Seatan in the courtroom, as he described to the judge what his life would have been like without his daughter, Alexandra.
She was special, not just to me, not just to her family, but to a lot of people.
The judge sentenced Paige Seatan.
Not less than 40 years, no more than 50 years.
Paige Seatan received nearly the maximum sentence after pleading guilty to motor vehicle homicide. The crash claimed the life of Alexandra Linscott and critically injured her mother, Elisa.
Today I find myself wishing I could trade places with Alexandra.
Paige's defense asked the judge for leniency, arguing for a lighter sentence in consideration of her circumstances.
It was a reckless and negligent act, but it wasn't intentional.
The defense argued that living with the consequences of her actions was a life sentence in itself. However, Alexandra Linscott's father countered, stating that no sentence would ever be enough.
No matter what you sentence her to, it will pale in comparison to what she sentenced my family to.
Prosecutors pointed out that Seatan was on probation for another DUI at the time of the crash. The judge remarked that this demonstrated her blatant disregard for the law.
The judge has taken a young 22-year-old girl and made an old woman out of her in one short morning.
She didn't deserve to lose her life because of my choices. I did.
She was sentenced to 8 to 16 years in prison for her role in the accident that took Alexandra Linscott's life. A woman accused of causing a car crash that killed her friend in 2013 has taken a plea deal. The suspect was allegedly drunk when she ran a red light in downtown Miami. It was an emotional scene in the courtroom as the family of Irina Reinoso, the woman who lost her life, spoke about their grief. Irina's mother, understandably struggling to hold back tears, told the judge that no parent is ever prepared to endure the death of their child.
I feel a loud roar inside of me that calls her name, and her silence is devastating. It's the answer that crushes my soul. Every day, I visit a dark and lonely place where I cry, scream, and feel an indescribable pain.
Irina Reinoso, who was especially close to her father, often enjoyed boating and fishing with him.
I have vivid image of Irina as a child, always happy, free, running after her daddy, or walking on the beach collecting seashells.
2 years later, the family remains heartbroken, even as they acknowledge that life goes on.
Yes, Your Honor.
Just like that, 24-year-old Mila Dago pleaded guilty to manslaughter and DUI as part of a plea deal that sentenced her to 4 years in prison. The incident occurred in August 2013. In the early morning hours, Dago was driving a smart car when it crashed into a pickup truck at the intersection of Northeast 15th Street and Biscayne Boulevard. Police reported that Dago ran a red light and was found to have been drinking, with a blood alcohol level twice the legal limit. Irina Reinoso, who was in the passenger seat, tragically lost her life. The two had only been friends for a few months. During the court proceedings, Dago addressed the victim's family in Spanish.
Words "I'm sorry" will never be sufficient to express my feelings.
We spoke with the victim's brother, who told us afterward that justice had been served and that his family felt somewhat at peace. A man convicted of driving drunk and causing a deadly hit-and-run crash was sentenced. The victim, Kathleen Venice, was an active member of her local saddle club, Legion, and Cattlemen's Association, and was involved in theater and events in Omaha. The man responsible for her death claimed in court that he was working to change for the better.
I've known Kathy for 30 years, and I miss her.
63-year-old Kathleen Benz lived on a farm in Valparaiso with her farmer husband. A passionate horse lover, she was also involved with the International Alliance of Theatrical Stage Employees in Omaha.
Oh, she loved it. She loved it just as much as she loved being on the farm, so she kind of had that mixture of both worlds.
Friends and co-workers say Kathleen Beans was on her way to a show when she lost her life. 36-year-old Justin Ayers was sentenced to 15 to 20 years in prison for motor vehicle homicide DUI.
I was very pleased. That's what we were after. I mean, the most that he could get.
On an afternoon in March, Justin Ayers, with a blood alcohol level twice the legal limit, was driving at 100 miles per hour when he rear-ended Kathleen Beniz's vehicle, pushing her into oncoming traffic at 75th and Maple. Ayers says that since the accident, he has gotten sober and has been dealing with unbearable remorse for taking Beniz's life.
Sorry what I did.
He had too much to drink and he made a really wrong decision.
Ayers expressed a desire to help others avoid making the same mistakes he did. Kathleen Benz's friends hope Ayers keeps that promise, as she was known for being an authentic person who always wanted to see others succeed.
I can bring her back. All we have left is her memory. So I'm very glad, and I hope that in the time that he has incarcerated, I guess is the word, that he continues on a path of bettering himself.
With good behavior, Justin Ayers will be eligible for parole in about 7.5 years. Once he is released from prison, his driver's license will be revoked for 15 years. The jury's verdict in Angela Bumia's case marks a significant outcome in DUI-related cases, with her being found guilty of murder, criminal mischief, wanton endangerment, and operating a vehicle while intoxicated. The not guilty verdict on tampering with physical evidence is notable as well. Dylann's parents expressed mixed emotions through their attorney, acknowledging the rare conviction for murder in such cases and expressing sadness despite the guilty verdict. The defense's surprise at the verdict highlights the unusual nature of the case.
The facts and circumstances of this case are so rare. Dylann was a very he's a perfect little child, and now he's gone because of what she did. And I think the jurors understand that. And I believe the defendant's behavior, which we'll comment a little more on tomorrow in penalty phase, I think speaks for itself.
Expecting her to not be found guilty of the homicide, based on what I said in my closing argument. So, we figured she'd probably be found guilty on the DUI, obviously, because we didn't even argue that in the closing. So,
Angela Bumia now faces a sentencing range of 20 years to life for the murder conviction. The prosecution was adamant about pursuing a murder charge, rejecting lesser charges like manslaughter or reckless homicide. They were clear in their closing arguments about their intent to secure a murder conviction, and the jury's verdict aligns with that goal. The rarity of a DUI case resulting in a murder conviction highlights the case's unusual and high-stakes nature.
We are here because of the choices
in the deliberate actions and the deliberate decisions of the defendant on June 26, 2010. Her decisions to drink after drink after drink after drink after drink after drink, and then one or two more for the road, are exactly why we are here.
In closing arguments, prosecutor Leland Halbart emphasized 17 key points to persuade the jury that Angela Bumia's actions constituted murder. He focused on demonstrating Bumia's extreme disregard for human life, a critical element for securing a murder conviction. This approach aimed to highlight the severity of her conduct and justify the murder charge over lesser charges.
What about driving while intoxicated and violently swerving so hard that you a child, run over a sidewalk, and run another 50 feet into two cars?
Angela Bumia displayed a lack of concern during her police questioning at the hospital. This was used to illustrate her indifference and reinforce the argument that her actions demonstrated an extreme disregard for human life, supporting the case for a murder conviction.
Cussed out the nurses, cussed out the EMTs. Don't convict her because she was cussing, but it shows indifference.
Elgin Cruels, Bumia's attorney, argued that despite Bumia admitting to drinking for hours at her stepmother's birthday party, hospital records indicated she was still able to handle herself reasonably well, even though she was over the legal limit. This was intended to challenge the prosecution's portrayal of her as having an extreme disregard for human life.
But as to the test that she was given, as to whether or not her speech was slurred, or as to whether or not her vision was okay, all that, according to the hospital records, all those were okay.
Elgin Cruels, Bumia's attorney, highlighted evidence suggesting that Bumia might have been distracted by a physical altercation with her boyfriend inside the vehicle just before the crash. He argued that this distraction contributed to the accident and questioned the fault, noting that Dylann was not on a sidewalk, which could imply some degree of responsibility on his part.
And in his expert opinion, the child was moving across the roadway and was not stopped.
During closing arguments, the prosecution emphasized Angela Bumia's testimony about drinking and driving. They highlighted her admissions from the stand, reinforcing the severity of her actions and intentions, which they argued demonstrated a disregard for human life.
Didn't completely stop at the stop sign. Drinking and driving shows indifference to human life. Bingo. Murder. That's it.
The jury found Angela Bumia guilty of murder, a rare conviction in DUI cases. This verdict highlights the prosecution's argument that her actions reflected a severe disregard for human life, meeting the criteria for a murder charge. Bumia now faces a sentence ranging from 20 years to life, reflecting the gravity of the jury's decision. The sentencing of Cameron Aguilar for the fatal DUI crash in Fresno's Tower District has brought mixed feelings for the victim's family. Aguilar, who was responsible for the death of Edward Austin, an injury to another person, was sentenced. Edward Austin's daughter spoke in court, expressing the deep, ongoing anguish her family will endure due to Aguilar's actions. Despite Aguilar's conviction and the time he will spend in prison, the sentence has done little to alleviate the family's pain or restore what was lost.
I've been extremely emotional since my dad's death. It has mentally, physically, and emotionally impacted me since the day he's died.
Cameron Aguilar was sentenced to just over 5 years in prison for his role in the fatal DUI crash that killed Edward Austin and injured another person. The courtroom was filled with the victim's family and friends who expressed their respect for the court's decision, but were hoping for a harsher sentence. They feel the punishment falls short, considering they will never see their beloved Edward again. The family's grief is intense as they struggle with the reality of losing an admired father and uncle.
But I know that she is a human being, and anyone can make a mistake. But not all mistakes cost another individual's life.
Cameron Aguilar received a sentence of 5 years and 6 months in prison after pleading no contest to DUI charges related to a crash in Fresno's Tower District. The crash resulted in the death of 44-year-old Edward Austin and injuries to another woman. Although Aguilar faced a maximum possible sentence of 7 years, the judge imposed a slightly reduced term. The victim's family and friends, who filled the courtroom, had hoped for the maximum sentence, but are grappling with the reality of their loss and the outcome of the case.
I believe that 7 years of Cameron's sentencing is not enough time to equal the impact and the amount of damage she has inflicted on my life and my family's life.
Alyssa Austin says that her father's death has deeply affected her in every way, mentally, physically, and emotionally. She misses him every single day.
You will never be able to see my milestones in life. You will never get to see me walk the stage for graduation this year, to get my first job, to have a baby.
The victim's niece mentioned that her uncle brought a lot of joy to their family. She hopes that sharing their story will help raise more awareness about the dangers of drunk driving.
I pray that she too carries the weight of my uncle and choosing to drive drunk, because that was 100% a choice. She could have paid for an Uber and Lyft or simply as a sober driver if she was trying to go somewhere. But she wasn't. She was just going to drift.
Aguilar has expressed that she feels deeply sorry for what happened and takes full responsibility for her actions.
Sorry doesn't begin to explain how I felt, how I've been feeling in my heart for the past 6 months. No one will ever be as disappointed in myself as I am.
At just 17, Alyssa hopes that the sentence handed down will help her begin to heal and remember her dad for the loving person he was.
And I love my dad, and I hope everybody knows that.
I'm not sure how or when I will forgive Cameron Aguilar, but I hope to God one day God gives me strength to do so.
At the end of the sentencing, the judge warned Aguilar that if she is caught driving under the influence again and it leads to someone's death, she could be charged with second-degree murder under the Watson law. With the criminal case wrapped up, the family now plans to focus on civil litigation. They want to seek justice not just for Austin, but also for the other person injured in the crash. 21-year-old Eric Watkins and his son were tragically killed by a drunk driver who was 3 times over the legal limit. The driver, who was going the wrong way down Highway 66, crashed into their car. Ginger Watkins, who survived the crash, had the opportunity to face the young man responsible for killing her family in court. The courtroom was filled with tears and deep emotions as the family of a young father and his baby pleaded for justice. In the end, 19-year-old Keaton Hannah was sentenced to 20 years. Hannah cried as Ginger read her victim impact statement before the sentencing. After the court session, Ginger left in tears, saying that 20 years was not enough justice for Eric and Briar.
I don't think it is enough because he took my husband and my son. My son was only 7 months, 17 days old, and this 18-year-old gets away with it, basically. That's really not enough. My son didn't even make it to his first birthday.
Prosecutors had asked for a 30-year prison sentence and 20 years of probation for Hannah, but the judge decided on 20 years in prison instead. The judge also said that once Hannah has served his time, he should share his story with young people to help prevent others from making the same mistake. After the court session, Hannah expressed his deep remorse for his actions.
Are you sorry for what happened?
More sorry than they'll ever know, I'm sure, ma'am.
Ginger Watkins said Hannah's emotions don't sway her.
No, it doesn't, because he only does it when the judge comes.
In Oklahoma, Hannah will need to serve 85% of his 20-year sentence before he can be considered for parole. He has already spent 1 year in county jail. This case revolves around Nicole Nachtman. In August 2015, in Carrollwood, Florida, Nicole ended the lives of her parents at their home. After discovering the bodies, the police determined that Nicole was responsible for the crime and filed charges against her. The prosecution presents evidence to the jury to aid the judge in determining the suspect's guilt. This process was followed in Nicole's case as well.
On August 20th of 2015, Miriam Deans was returning home after a few days off at Jacksonville. Not off, I should say. She was actually working. She was working with the Navy. She was on assignment. She'd been recently promoted to captain. She was coming to what she thought was her home. But in reality, ladies and gentlemen, she was walking into a trap. A trap that was set up by this woman right over here. Her own daughter, Nicole Nachtman. You see, ladies and gentlemen, the evidence will show that on August 20th of 2015, Nicole Nachtman had decided that rather than dealing with a strict, demanding mom, a mom who she could not feel like she could please, she decided to eliminate her from her life. Did she run away to do that? No. Did she go seek help from family? to do that? No. She put 3 into her mom. The evidence will show that on August 20th of 2015, defendant was a young woman who was having problems handling responsibility. She liked to be on a computer. She liked to live in her anime world and just spend her time on the computer, blogging and doing things like that. She was slipping in her grades at school, even though her mom is providing her everything she needed to succeed. And one thing had happened right around this time that will finally precipitate all this. She failed to get her housing for her junior year at Florida State. She failed to submit the paperwork she was required to submit. So rather than face the anger of her mom, she decided to kill her. But there was one person in the way of that plan, one person in the way of her finally taking care of getting rid of her mom. And that person was a man who just happened to be living in the same house, who happened to be married to her mom, her stepdad, Robert Deans. See, Robert Deans, he was a retired police officer that the mother and Robert Deans had met in Virginia and had married, and he had moved down here to Carrollwood with Miss Nachtman and her mom, Miriam. So in order to kind of understand how we got here, let's talk a little background on what the evidence was going to show you. Let's go back to where this started. The evidence is going to show that Nicole Nachtman did not have an easy life. It was not an easy life. When she was very young, her mother and her father, Ronald Nachtman, got into a very bitter custody battle. Lasted for a while. Allegations made both ways. A difficult time for a young child being torn between two parents. The evidence is going to show that ultimately Miriam Deans was awarded custody of Nicole Nachtman, and at the age of 4, she did not see her father again. You're going to hear that Miriam Deans, as a result of work and school and so forth, was traveling a lot. She lived in different areas of the country. She lived in Texas for a while. She lived in Virginia for a while, and she lived obviously in Tampa for a while. And as a result of that, Nicole Nachtman was going to lots of different schools, not maintaining one particular school district. And so clearly there was probably difficulty making friends, maintaining friends. But what you will hear also, and you will hear this from the defendant's own brother, Joseph Carey, she was a happy girl. Despite everything that was going on, she was happy. She was being provided for. He'll tell you that, mom took great care of her, that they had a good life, even though it was kind of crazy with the movement and stuff. And Nicole was happy, growing up normal. In his mind, she loved to dance, she loved to sing, a typical young girl. Mother stayed very involved in Nicole's life, all her life. She continued, despite going to different schools, to do okay in school. Her grades stayed okay, and she continued to move forward and progress in her schooling. So let's fast forward to the summer of 2015. At this point in time, Nicole Nachtman had completed 2 years at Florida State University. Her first year, she spent part of it abroad in London. She spent a semester abroad in London, and her grades were good. She got back from London, and in her second semester, her grades continued to be okay. And you'll see her transcript, and you'll see evidence of her grades. Come her sophomore year, her grades started to slip. She was getting very mixed grades, if you call it that. She would get B's and then some F's, and B's and some F's. She was clearly struggling at Florida State University at that time. When she was not in school, she was living at home. It's a nice home. You're going to see pictures of it. It's a nice home in Carrollwood. Has a pool right on the lake. She had a couple of dogs, some cats. in a nice little subdivision in a little cul-de-sac. And she lived there with Robert Deans and Miriam Deans, her mom and her stepdad. Also here, she had a lot of other family here in Tampa. She had some uncles, she had cousins, she had a grandmother who she often stayed at her house. Lots of people she could communicate with, talk to, and who were around. So in that summer of 2015, Nicole Nachtman went to spend a month with her older brother, Joseph Carey. And you're going to hear there's a big age discrepancy. It's almost like 12 years. Now, Joseph Carey had lived in Tampa for a little while, and when his mom wanted to move to Virginia, he didn't think it was a good idea and didn't want to go with her. So he ended up staying with his grandmother here until he graduated from high school, and he eventually joined the U.S. Air Force, where he stayed in the U.S. Air Force and continues to be working in the U.S. Air Force. He's currently now stationed in Tacoma, Washington, working for NORAD. So you're going to hear from Joseph Carey that he and Nicole Nachtman tried to spend time together during the summers or times when they could get together. And Miss Deans would encourage that and would encourage Miss Nachtman to go spend time with her older brother. And you're going to hear from Joseph Carey that summer she was there. She was quiet, introverted. She was constantly on her computer. And he had to struggle to get her to go out and do things. And he kind of thought, well, this is probably typical teenage, even though she's a little older than a teenager at this point. She's 21 years old. But, something that younger people do. He got along great with her. They confided in each other. They were confidants. You will hear that they did talk from time to time about mom. But you will not hear that Nicole Nachtman ever told him one time that her mama her or did anything to her. You will hear that they did talk about typical things that brothers and sisters talk about. Oh, mom, mom, demanding mom, things along those nature. Joseph Carey, her closest person, had no clue that a month later she was going to kill his mother. So we moved to the end of the summer. August 18th, I've told you Miriam Deans leaves to go to Jacksonville. You're going to see a receipt in her car from the days that she was staying at the hotel in Jacksonville, again, where she was on assignment with the Navy. She left Nicole Nachtman and her husband, Robert Deans, at the house at that time. Nicole Nachtman was supposed to be going back to FSU at this time as well. Classes were about to start, housing was opening up, kids were moving in. This was the time of the summer, obviously, when that starts to happen. So in Miriam Dean's mind, Nicole Nachtman was gone. She was heading back to school while she went to Jacksonville. Robert was home. But unbeknownst to Miriam, at this point in time, Nicole Nachtman had failed to put in her paperwork. And she had no housing. On August 18th, she had no housing. She did not want to tell her mom. So on August 18th of 2015, this is where Nicole Nachtman finds herself. Enrolled at FSU, but nowhere to stay. And this, ladies and gentlemen, this is the spot where her plan takes shape. Now Miriam Deans is gone, and it's just Robert Deans in the house with Nicole Nachtman. The last time Robert Deans is seen alive is on August 18th of 2015 at a Publix. You're going to see that video. And you'll see Mr. Deans there doing his shopping. You'll see the hat he's wearing. A blue Titleist type hat. Somewhere between the moment he left that Publix and the next morning of August 19th, Nicole Nachtman put a in the back of his head. Instantly. The person who stood between her and her ultimate goal of mom had been eliminated. And the evidence is going to show you he was eliminated with his own gun that he kept in the drawer beside his bed. The evidence is going to show that the next morning, on August 19th, Nicole Nachtman received some good news. Her housing had been approved. Paperwork had come through. She was accepted into housing, and she had overflow housing. All she needed was a $100 deposit. She didn't have $100. Normally, she would ask her mom for $100. She doesn't do that. Obviously, she can't ask Robert Deans, because by this point, Robert Deans is dead. And we know that, and I'll tell you why we know that in a few moments. So she calls her cousin, who lives about 2 miles north, still in Carewood, David Lear. And she says, hey, David. She calls him in the morning. I need $100. He says, hey, I'm at work. Let me call you later when I get off work. He gets off, goes home around 3 o'clock, and she calls him back because he'd forgotten to call her. And she said, hey, I need $100. He said, oh, you know what? I have it with me. Come on over.
All members of the jury are present and seated. Everyone else may be seated this time. Ladies and gentlemen of the jury, welcome back. I usually wait till the very end to thank you for your hard work and dedication, but I think under the circumstances this morning it's appropriate to thank you perhaps now and when I release you. But it's my understanding, the bailiff has indicated to me that the jury has reached a verdict. So my first question is, normally, whether you've elected a foreperson, but we know from prior communications that that is juror number 1. Is that correct? And juror number 1, do you have, well, first of all, has this jury reached a unanimous verdict in this case?
Yes.
Do you have the verdict form, juror number 1? If you could please give that verdict form to the bailiff, Deputy Oliver. Thank you to the foreperson. I will review the verdict and then I will give it to the clerk to be published. Ms. Nachtman, if I can please have you stand. And if my clerk will please publish the verdict.
Yes, Judge. State of Florida versus Nicole Nachtman, case number 2015 CF 12204. We, the jury find as follows as to count 1 of the charge. The defendant is guilty of murder in the first degree as charged. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant personally discharge a firearm? Yes. During the commission of the offense, and as a result of the discharge of the firearm, was caused to Robert Deans? Yes. We, the jury, find as follows as to count 2 of the charge. The defendant is guilty of murder in the first degree as charged. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant personally discharge a firearm? Yes. During the commission of the offense, and as a result of the discharge of the firearm, was caused to Miriam Deans? Yes. So say we all, dated this 3-day August 2019, Daniel Maudlin, foreperson of the jury.
Ms. Nachtman and defense counsel, you may be seated at this time. Would either side like the jury polled?
Yes, Your Honor.
Ladies and gentlemen of the jury, what that means is my clerk is going to ask each of you individually whether the verdict that was published represents your verdict in this case. You may proceed.
Yes, sir. Daniel M., is this your verdict? Yes. Mary F., is this your verdict?
Yes.
Jimmy D., is this your verdict? Yes. Jeremy S., is this your verdict? Yes. Heather Z., is this your verdict?
Yes.
Anna O., is this your verdict?
Yes.
Timothy F., is this your verdict? Yes. Anthony R., is this your verdict? Yes. James P., is this your verdict?
Yes.
Ricky C., is this your verdict? Yes. Gabriella G., is this your verdict?
Yes.
And Patsy H., is this your verdict?
Yes.
Thank you. Is there anything from the state before I release the jury?
No, Your Honor.
Is there anything from the defense before the jury is released?
No, Your Honor.
Ladies and gentlemen of the jury, this is the time when I say thank you very much for your hard work and your dedication in this case. This was a very long trial. You gave us your undivided attention. You came here every day and you worked hard, and you worked very hard in the end with the verdict until this late hour. And for that, we appreciate your service. I'm going to thank you on behalf of the attorneys, the parties, the judges here in the 13th Judicial Circuit, and the citizens of Hillsborough County. I want to let you know now that I will release you from all of my prior restrictions about not doing any research related to the case, about not talking about the case to others. When you go home, I'm sure friends, family members, people at work are going to want to talk to you or ask you questions. It's up to you, but you are free to talk to them now about the case. Additionally, I want to let you know about your deliberations. They carry with them a very special protection, and you cannot be forced to talk about your deliberations except by court order. However, if you wish to talk about the jury deliberations that happened back in the jury room, you are free to do that. That is up to you. We're going to have the bailiffs walk with you. It's dark outside. We're going to have the bailiffs walk you to your cars in the garage. We have letters for you that say that you were here both weeks. And at this time, again, I want to thank you very much for your very important civic duty. I said in the very beginning that Abraham Lincoln said a very long time ago that the greatest service you can give to your country in a time of non-war is service on a jury. I still believe that today, and we appreciate you very much. Thank you all, and have a very safe trip home. All rise for the jury. Jury has exited. Everyone may be seated. I'll ask the state, is there any reason why we can't proceed to sentencing at this time? Would you like the victims present? Would you like a sentencing date? Or would you like us to proceed to sentencing?
If you would proceed to sentencing, Judge, I don't think there's any victims who might be present.
All right. Is there any reason from the defense why we should not proceed to sentencing at this time?
No, sir.
All right. Ms. Nachtman, the jury having found you guilty as charged on counts 1 and 2, I am going to adjudicate you guilty at this time on each of those counts and sentence you to life in Florida State Prison on each count to run concurrently. I will impose all standard court cost fees and fines. You will have 30 days to appeal the judgment and sentence entered against you. Thank you.
Will you appoint the public defender for purposes of the appeal, please?
I will appoint the public defender for purposes of the appeal. If you'll submit me an order on JAWS, I will sign it as soon as it is submitted.
Yes, sir.
Is there anything else before we conclude court?
Nothing from the state, Judge.
Anything from the defense?
No, sir, thank you.
All right, again, thank you all very much. Have a safe trip home. Oh, I got to sign. Right. I'll stick around.
Your Honor, we've got some equipment. Can you pick that up in the morning?
I don't foresee any problem with that.
I want them here. They'll just have to check with the bailiffs because you'll be at conference.
I'm sure Sally.
Yeah,
Sally
and Sally can get in.
Okay, I know Sally will find.
Yeah, I have no problem with you leaving it here. It should be safe.
This case centers on Zachariah Anderson. On May 17, 2022, in a jealous rage, Zachariah stalked and killed Rosalia Gutierrez, the boyfriend of his ex-girlfriend, Sadie Beecham. He then hid the body, which remains undiscovered. However, police found blood in Gutierrez's apartment and, after an investigation, arrested Zachariah. Sadie, who suffered immensely after Rosalia's death, recounted a happy memory in court, filling the atmosphere with a profound sense of dread.
My daughter and the kids would stay at his house the night before her birthday, so then I could decorate the house and get everything else set up for her birthday party after his house. So the plan was then the next morning I would go to his house, meet the kids there, present the birthday present to Olivia or to our daughter, and then take the kids back home with me, and then we would have our birthday party there without him.
And on the night of the 24th, did the defendant take the kids to his house as planned?
Yes, he did.
And did you then have a company come to your house that night?
Yes, I invited Rosalio to come over.
And was he going to help you decorate for the birthday party?
Yes, we eat dinner and he helped me decorate.
And did Mr. Gutierrez spend the night that night?
Yes.
And did something happen in the early morning hours that caused you concern in terms of hearing something?
Yes, so we were getting ready to retire, to go to bed. I don't know, it was like 2:30 in the morning. We just laid down, and then I'd heard the doorbell ring. And I was kind of like, what's that? And I got up, and we both got up and went to the door and I didn't see anything or anybody. So then I went to the window. I have like a bay window that was outside of my bedroom, and I kind of opened up the blinds and peeked out. And as I peeked out, I saw a black car going past the road right in front of the house. And I just assumed, knowing that Zach had a black car, that could have possibly been him. So that's my thought, was that, oh my goodness, he was here at the house and rang the doorbell or something.
And you indicated, obviously, Mr. Gutierrez was there that night. Was the plan for him to be at the party the next day?
No. Yeah, he was there that night. I kind of briefly told him I thought that my ex had been at the house. And so then that morning, he went out to his truck and he came back in and he was like, hey, did I go in my truck last night? I was like, no. And he's like, well, everything's all messed up in my car and things are like outside of my glove box and they're laying on my console. And he's like, I think he may have gotten in my car last night. I'm like, oh boy. So, we just kind of parted our ways. I said, I have to go to this birthday party. We agreed to talk later.
We're just going to show you what's on State's Exhibit 1, photograph number 1. Do you remember, is this the truck that Mr. Gutierrez was driving or had driven to your house that night that was gone through, in his words?
Yes.
And is that with license plate? Looks like Colorado BAZT26.
Yeah, Colorado plates.
Now, you had talked about what the plan was supposed to be for your daughter's birthday. What ended up actually happening on the 25th after the doorbell incident early that morning?
I went to his house and had the get together. And Zachariah's sister surprisingly came into town unexpectedly to surprise our daughter. Her daughter was very happy about that, and she was not very happy with me. She refused to hug me or kiss me that day. She didn't talk to me very much. I kind of had a feeling something was off, and that maybe she knew that Rosalio came over last night, but I didn't know how. So, it was kind of awkward. But then we were getting ready to leave, and our daughter asked if her aunt and everybody could come over to our house. So I had agreed, with the caveat that they would all stay outside and hang out on the deck, because I, again, did not want Zach in the house, and especially after having this feeling that my daughter was hating me and it was her birthday, and it was just also weird. So, like I said, I agreed to let everybody kind of come back to the house and hang outside. We opened presents, had cake and everything, and then our daughter wanted to stay over at her aunt's house. So I agreed, said that was fine. And then, so as everybody was leaving, Zachariah wanted to stay and talk to me. And I said, well, can we talk with your family here? And he's like, no, they can go. And I said, no, I want to talk with your family here. And so he confronted me kind of at the door and said, I had this premonition that you were with somebody else last night, and you were wearing this pink tank top, and you were listening to this song, and I know what song you were listening to, and come on, tell me, and just bantering me about, you know, this premonition that he had, and and I have these when, you know, when I break up with people, and you know that, and you know, I'm like, I don't know what you must have been here last night. The only way you would have known any of this. And he's like, no. And then we got into some kind of a back and forth about it. And he started walking away. And as he was walking away, he was like, yeah. His name is, and he just rattled off his name, his full name, and yelled it at me and said, and, you know, he's Mexican, and just rattled off things he should not have known. And so that I said, you know, you had to have been here. And he didn't tell me until he finally kind of came close to me and said, yeah, I was. I needed to know. And yeah, that was kind of the conversation.
I'm going to approach you with what's been marked as States Exhibit 51 and 52. Can you just tell me what these are?
Pictures of the inside of my house, the birthday party with the decorations and my kids.
Judge, I would ask to publish these to the jury without using the Elmo, given the minors.
Can I see them first?
Oh, absolutely. 51 and 52. Ms. Beecham, in these pictures, is that what the decorations looked like the night that you and Mr. Gutierrez set up the night before the party?
Yes.
In re the matter, State of Wisconsin versus Zachariah Joseph Anderson, as to the first count of the information, we, the jury, find the defendant, Zachariah Anderson, guilty of stalking Sadie Beecham as charged. As to the second count of the information, we, the jury, find the defendant, Zachariah Anderson, guilty of stalking Rosalio Gutierrez as charged. As to the third count of the information, we, the jury, find the defendant, Zachariah Anderson, guilty of intentional homicide of the first degree as charged. As to the fourth count of the information, we, the jury, find the defendant, Zachariah Anderson, guilty of hiding a corpse as charged.
Oh, I put it in the wrong stack. Yeah, you may be seated. Members of the jury, are these your unanimous verdicts? You have heard the clerk reading verdicts finding the defendant guilty as to each count of the information. I'm going to pull you by seat number 1 through 6 across the top, 7 through 12 across the front. If you agree with each and every one of these verdicts, finding the defendant guilty as charged, please respond by saying yes. If there is any of the verdicts with which you do not agree, even one, please respond by saying no. Were these and are these now your verdicts? Number 1, 2, 3, 4, 5, 6, 6? Yes. No, 5?
Yes.
Okay, 6, no, 7.
Yes.
8, 9, 10, 11, 12.
Yes.
All right, any further requests with respect to the jury?
Not from the state.
No, Judge.
All right. Folks, I want to thank you for your service in this case. I could not have asked for a more cooperative, pleasant jury to work with. And in no way am I commenting whatsoever on the outcome of the case. In terms of the length of the case and what the original expectations were, some of the interruptions and long breaks, and I could go on. You have been, I've never worked with a more patient and cooperative jury, and it's been a true pleasure for me to do that. This is far more important than most people realize. I mean, our entire freedom in this country is dependent upon people like you who take time off at great sacrifice to perform this service to their fellow citizens, and it's a guarantee of freedom against oppressive government that other countries don't have, and it's because of people like you that it's kept strong and handed down to our children and the generations which follow us. So there is no way I could adequately express the gratitude we have for you folks. And I want to advise you that you're never under any obligation to discuss your service on the case with anyone. You're welcome to. There are no restraints in terms of how much or how little you want to discuss it. Sometimes people will contact you. Very rarely some of the lawyers sometimes will contact people and just ask for pointers or whatever. Sometimes the media will. I haven't seen a lot of that lately, but keep in mind that you're welcome to talk or welcome to say, I don't care to do that. And you're right either way, whichever way you decide. There is only one possibility that you would ever be required to answer any questions about your service here. That's very remote. I've been in the criminal courts over 50 years. I've only had one case where that occurred, and it was a very minor matter. So I would not expect that you would be asked to do that. If that did happen, that request would come directly from the court and would be a court proceeding here in the open court. Other than that, you don't have to answer anybody's question if you don't want to. You're ineligible for jury service for 4 years. You've already done.
They want to know if they could have a lifetime.
A lifetime exemption. That I can't do, but you certainly have earned one, if that's what you wanted. But I'm hoping that maybe one or more of you may have enjoyed it enough to want to participate again. But in any event, for 4 years, you shouldn't be contacted about jury service. And go with our greatest gratitude and have a wonderful day. Thank you. I was very, very moved by the testimony or the remarks today by the lives that were touched by your vicious criminal act. And I wondered, to what extent did this man even think about these things? Was he so wrapped up in himself that it didn't even matter to him the effect it would have on the people who loved him? So if I got into the issue of deserve, that would certainly be at the forefront. I will say that you have been cooperative throughout these proceedings. You did not contaminate this courtroom by giving perjured testimony, which a very large share of our offenders do. The degree of planning of the crime and the concealment is very concerning, and speak to long-term determination of lawless behavior. On the first count of the information, it is the sentence of the court that your custody be committed to the Department of Corrections for a period of 2 years, followed by a 2-year period of extended supervision. On the second count, for an identical sentence to be served consecutively. On the fourth count of the information, hiding a corpse, for a period of 6 years of initial confinement, followed by 5 years of extended supervision, to be served consecutively to counts 1 and 2. And on the third count of the information, It is the sentence of the court that your custody be committed to the Department of Corrections for confinement in the Wisconsin State Prisons for the remainder of your life. This sentence is consecutive to and not concurrent with the sentences on the other 3 counts. The period of eligibility for extended supervision will not occur until 40 years following the date upon which you start the sentence on count 3. You have rights to appeal with respect to the disposition of this case, and your attorney will review them with you. If you understand your rights, tell Ms. Muller. She'll have you sign a document acknowledging that. There's credit to be allowed for 1,092 days in custody to be applied to the sentence in the sequence 1, 2, 4, and 3. All sentences, as I think I indicated, are to be served consecutively to one another. The conditions of its extended supervision, you know what, I think you're right. Although I did do one and it didn't, and it hasn't come back yet. You'll abide by all rules and regulations established for you by your supervising agent, pay the costs and disbursements of this action, repay to the, well, that one, no. The matter of restitution is to be referred for examination by court commissioner and return to the court with recommendation within 60 days. No contact with any member of the those who are statutory victims in this case, except as is allowed by your supervising agent.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.